Good morning, everyone, and welcome to the final installment of our quarterly on-site webinar series for 2022, Construction in 2022, the Year in Review. I'd just like to run through a couple of housekeeping notes. You'll note that the audio and video functions have been disabled, and that's obviously to minimize interruptions. If you'd like to ask a question or comment on any of the presentations, we'd ask you to please use the Q&A function, and we'll either write a reply or deal with the question during the Q&A session at the end of the webinar. Of course, alternatively, you can always contact one of the speakers and they'd be happy to answer any questions that you might have. Hopefully you can see the presentation. If not, we have emailed it to you, so please check your inboxes. So, 2022, there were so many legal developments that affected the industry that it's hard to know where to begin. The year saw important strides to make the benefits of adjudication more widely available, and in particular by way of the Court of Appeal decision in Abbey and Simply, in which WFW acted for the successful appellant. This was also a year in which the industry continued to grapple with the consequences of the ongoing building safety crisis. The UK's Building Safety Act 2022 passed into law, and there were a series of important decisions from the courts concerning liability for construction defects and the standards to be satisfied when bringing defects cases. Today's webinar comprises 3 bite-sized updates, bringing you up to date on the key legal developments from the past year. First up, we have Abbey and Simply, a game changer for the construction industry, which will be presented by Hembling, the successful appellant. Then we have Martlet Homes Limited and Mulalley Co Limited. Is this a green light for employers' claims for defective cladding? And Theresa will be presenting that discussion, Theresa Mohammed. And finally, last but not least, Ryland will be discussing the cost of living crisis and construction and how to protect your projects. So I'm now going to hand over to Hembling.
Thank you very much, Rebecca, and good morning to all of you, and thank you very much for attending today. So the first of these presentations is about the Abbey Simply decision, and that's a decision that was handed down in June by the UK Court of Appeal, which considered for the first time the statutory meaning of a construction contract. Now, in our next slide, you will see that members of the legal profession have considered this a very important decision, and it's not just what we say about it here at WFW, it's about the decision and how it's been viewed more broadly. And it's important because it extends the right to adjudication to a broader number of contracts to those that previously benefited from that right. And that matters because adjudication is a quicker and less expensive procedure than litigation for resolving construction disputes. So in adjudication, for those who may not have had the pleasure of going through the process, the parties exchange submissions, generally on paper. An adjudicator is appointed to decide the dispute. He or she will hand down a decision, perhaps without a hearing. That decision will be temporarily binding until such time as the matter is finally determined by a court. But in many cases, if not most, the decision of the adjudicator is final and binding, and the parties accept the adjudicator's decision without any further proceedings being necessary. So in our next slide, you'll see the background to the decision was the Housing Grants Construction Regeneration Act. That's the statute by which adjudication was introduced, and that right it was introduced on the 1st of May 1998, has been very widely adopted and has been very popular. And since adjudication became popular and was adopted, there have been very many cases about adjudication and about how the Act ought to be interpreted. But very few of those cases until now have addressed the central question of what is a construction contract to which this right of adjudication applies. And that was the issue essentially in the Abbey Simply case, and it concerned the interpretation of section 104.1 of the Act. And that's the basis really where the Act defines where the construction contract comes into being to which the right to adjudication applies. So in our next slide, you'll see that I've summarized some of the key points relating to the decision. So we've had this right to adjudication, but that must also be viewed in the context of other legal developments from the 1990s, which have sought to restrict access to bring procedures for damage to buildings, except in cases where there's a contractual relationship. So because of that restriction, many contracts have developed known as collateral warranties that provide links to parties that otherwise would not benefit from the links and contractual relationships with one another because they didn't commission the original construction works. And those contractual links are important because it means that tenants, landlords, funders have links to the consultants and the contractors who carried out the original works and services. And without those mini contracts, there wouldn't be an entitlement to recover for defects to buildings after building works were complete. So in the next slide, you'll see that I summarize very briefly the facts in the Abbey Simply case. It's not necessary to review that in any further detail other than to remind ourselves that it's a case that arises out of a relationship between a landlord, a tenant and a contractor, a structure that's seen on very, very many construction projects. There were construction defects that arose after the works are completed. The landlord had the benefit of a contractual link through the building contract. The tenant had a link with the contractor through a collateral warranty. The issue really was whether there was a right to adjudicate under both the building contract through which the original construction works have been performed and the collateral warranty, the mini contract that sat alongside it. In our next slide, you'll see that I identify some of the key parts of the decision. So the Court of Appeal, it looked at the section 104, the basis where the construction contracts are defined, and it said that the right to adjudicate wasn't just limited to the contract under which the original construction works were performed, but it could also extend to these ancillary contracts, such as the collateral warranties, because the Act was broad enough to include reference to the fact for contracts arranging for the carrying out of construction operations. So that particular reference in section 104 meant that the parties weren't just confined to the original contract under which the works were carried out. Whether or not a collateral warranty would be a construction contract for purposes of the Act and attract a right to adjudication very much depends on interpretation of the individual document. And so the Court of Appeal said to decide whether or not a statutory right of adjudication ought to apply. But there were two key pointers that the court said suggested whether or not a right to adjudication would attach to a construction contract under the Act. The first was whether there was a warranty given not only in relation to past performance, but also in relation to future performance. The second key point was there had to be satisfaction of another part of the Construction Act, section 109, where there was a requirement for relevant payment provisions to be included in a construction contract. So the Court of Appeal said that that requirement could be satisfied even when there was nominal consideration, such as for payment of £1. It wasn't necessary to have a very detailed procedure setting out what needed to be paid by reference to instalments. So long as there was the warranty in relation to past and future performance, so long as there was some form of payment consideration under Section 109, they would be key pointers in identifying whether or not a statutory right of adjudication would attach to a construction contract. So in my next slide, I pick out the two key points that I was just talking about, and this is important for what we're going to do next. So first of all, we need to look for that warranty in relation to past and future performance, was carrying out, will continue to carry out. And secondly, we need to look for drafting dealing with those nominal payment arrangements, even if it's just for the payment of £1. So in our next slide, what we'll look at are some examples, and we'll go through various types of document which statutory right could potentially now apply given the Court of Appeal judgment. And maybe we'll have some engagement. We're going to have a poll, and we can identify between us whether we think the individual contracts might fall within the scope of the Act as the Court of Appeal has now interpreted it. So the first is a template collateral warranty. So again, it's a type of collateral warranty that will be seen on very many projects. So that particular drafting, if we look at the detail, the object of the exercise, your homework is to assess whether, by reference to what we've just looked at, we think the statutory right of adjudication might apply to that particular drafting. So this is where the first poll comes in. So so the question you need to consider is, would a statutory right to adjudication potentially apply on the drafting of collateral warranty number 1? So it may be helpful if I just show once again the drafting of that collateral warranty, take an account of what we've just seen. What do we think? Do we think, based on example number 1, would the statutory right of adjudication apply? Does it satisfy those two key points that the Court of Appeal identified, the warranty in relation to past and future performance? Does it include some form of payment mechanism? So please vote now. So the results of the poll will be displayed very shortly. Vast majority is yes, that there would be a right to adjudication, and I think that is the right answer. So we go to the next slide, and I think that's the right answer because I've highlighted there on the drafting the two key provisions that we need to look out for. So first of all, we have a form of consideration. We have the payment of £1, and secondly, then section 1.1a of that draft, we have not only the warranty in relation to past performance, but we also have the warranty in relation to future performance. We'll continue to exercise that reasonable skill and care. So well done, everyone. A good start to the 4 polls. So let's look at another example. So this is example number 2, another type of collateral warranty, not at all unusual, will be seen on very, very many construction contracts, and very many projects will have warranties of this particular type. So the question we now need to consider, as per our next slide, is whether we think statutory adjudication rights could apply to that particular drafting based on the Court of Appeal's guidance as to when the Construction Act will apply. So again, we have that drafting on the screen. Please now vote. Do you think a statutory right to adjudication would apply to collateral warranty drafting number 2 based on what the Court of Appeal have now told us to look out for? So my colleagues will share those results very shortly. And vast majority, 85%, is that no, the particular drafting. And we look at the next slide, you'll see that although we have the warranty in relation to past and future performance, what we don't have, and you'll see it on our next slide, is that key consideration for the payment mechanism to be satisfied. So this particular drafting doesn't comply with Section 109 of the Act. What that means then is that the statutory right to adjudication can't attach to that particular drafting because Section 109 doesn't apply. So our next example, so let's assess between us how far we think the principles set out by the Court of Appeal could apply to other parts of the construction pack. So here we have a letter of reliance. So that's a document where a beneficiary perhaps wants to reply a benefit to a report, such as maybe a report about some ground investigations. So it's not unusual for particular warranties to be given in respect of letters of reliance. So taking account of what the Court of Appeal said, do we think that a statutory right of adjudication could potentially apply to a letter of reliance? So another poll coming up. We'll put the drafting back on the screen so you can assess whether or not there might be a statutory right to adjudication based on that particular drafting. And the results are slightly more balanced. So 40% yes, 60% no. So I think the answer is that on this particular drafting, so we have the consideration, the payment for £1. So we do satisfy the requirements for Section 109, so that's good. But on the next slide, you'll see that what we don't have is the warranty in relation to future performance. We have the warranty for past performance. And the reason for that is in letters of reliance, the end usually set at the date of the report to which the letter of reliance attaches. So once the report has been prepared and provided, that's when the warranty usually ends. There's usually no ongoing works or services to which a future performance warranty is given. And where there's no future performance warranty, it's unlikely, based on the Abbey Simply decision, that the statutory right of adjudication would now attach. Our last example that we'll look at is a parent company guarantee. So final poll of the morning, do we think that a statutory right of adjudication would apply to the parent company guarantee based on that particular wording? So let's put the drafting back onto the screen. Please do vote as to whether you think the statutory right of adjudication might apply on that particular drafting. So the results just coming in now. And fairly evenly split. So yes, 54%, no, 46%. And I think the answer is that we can see with the highlighted item that we do satisfy the requirement under Section 109, so that's good. We do have a form of payment mechanism, so we don't need to worry about that. Where I think it's less clear, and we'll see it on the next slide, is the extent to which the warranty is given about past and future performance. So this is a guarantee in relation to performance. We've got principal liability, but the drafting isn't quite as clear cut as a warranty in relation to past and future performance. I think it's arguable either way on that particular drafting, and no doubt we'll see many cases in the future testing the principles set out by the Court of Appeal, trying to see whether or not the principles from the Abbey Simply decision extend more broadly to other types of construction contracts other than collateral warranties, and if so, where do we draw the line? So finally, I have some guidance that we can take away from this. So if you're providing a collateral warranty, I think first of all, you need to understand what sorts of warranties you've already given. So I think you need to go through your archive, have a look at the documents, undertake that analysis based on the past and future performance warranty, look to see whether the Section 109 requirement is satisfied. Are these types of warranties to which a statutory right of adjudication could apply? Secondly, I think legal advice should be taken to identify what edits ought to be made in the future regarding collateral warranties and other types of documents that are provided to beneficiaries. And there's also a strategic decision ought to be taken as to whether a business does actually want to benefit from a statutory right of adjudication in all cases, or whether they would prefer to argue it on a case-by-case basis. If you're receiving party, so if you're receiving a collateral warranty, the takeaway from our next slide is that again, you need to carry out the audit, you need to understand the types of document that you've been given. You'd want to know whether you can take legal proceedings or whether a quicker form of dispute resolution will be open. Where there's a template attached to a contract and warranties are to be procured based on that template, there's a strategic decision as to whether a beneficiary would want to settle for that particular drafting, or whether they would prefer to try and renegotiate terms to ensure that statutory right of adjudication or a contractual right even applies to collateral warranties and other documents in the construction pack. On an ongoing basis, you'd want to check the past and future performance. You'd want to make sure, if you're a beneficiary, that the quicker and less expensive form of dispute resolution is open. So you'd want to make sure that there's a statutory right of adjudication where possible. And you'd also perhaps want to consider express drafting, particularly in those documents such as guarantees, where it could be ambiguous, it could be argued either way. You perhaps want to include some express drafting to make sure that the right to adjudication is clear. So they're the key takeaways from the decision. No doubt there'll be further cases in the future, testing those principles and seeing where the line ought to be drawn. And this is an issue we'll keep under review and we'll monitor. We'll come back to you in future editions with updates on the point. That's all from me today. Now I hand over to Theresa Mohammed.
Good morning, everyone, and thank you, Barry. Next slide, please. I think it's important at this juncture to set the scene. So we had the Grenfell Tower fire in 2017, and that really has shaken up the whole industry. And what then ensued was a whole multitude of cladding disputes. Because believe it or not, even in multi-party actions with very sophisticated parties, it really wasn't clear what was on buildings. The as-built data was very poor, and there was general confusion about what standards did apply. So that post-Hackett review, we're trying to get to grips with new legislation and requirements and really important issues of competency, but at the same time, struggling to understand what actually applied to their historic buildings. So really, this has been a very challenging and overwhelming time, but of course, with an important purpose. Now, what you can see over the history of the building regulations is obviously we've been very output performance focused, but actually over the years, what has happened is we've been allowed to use combustible products. That has crept in through the building regulations. And that, when you combine it with poor procurement choices that are very price dominated, poor site supervision, again, because of lack of funds, it's no surprise that we're in the position we are today. And really what we have seen is a whole culture of bad practices. Now, of course, that's what Building Safety Act is. But until this important decision of Martlet and Mulalley, we didn't actually have anything that we could point to that gave us judicial guidance. Next slide, please. So let's talk about this case in a bit more detail. This was a housing association that owned 5 tower blocks in Gosport, and the materials used on this building included expanded polystyrene insulation. Now, of course, this is extremely combustible, and the Grenfell inquiry actually described materials of this kind as essentially fuel. And if you combine that with a failure to compartmentalize, you have a pretty toxic and lethal combination. In addition to this, the mineral wool fire barriers were defective. And again, because they were defective, this totally undermined the fire strategy of the building. So what did they do? Martlet, when they discovered this, once they started investigating after the Grenfell fire, as many employers did, they installed a waking watch. And actually, as I said at the beginning, this was a particularly important decision because these cladding disputes had previously fought to trial. So whilst that is good for the clients in terms of resolving their disputes without trial, it actually didn't give us anything we could rely on. And so in many respects, a lot of the advice clients were being given was to an extent speculative. Next slide, please. So Mulalley, who were they? So for those of you that don't know, they're a design and build contractor. They were engaged to install external wall insulation. And what essentially had happened was they'd used something called dot and dab to install. And actually what they were meant to do is provide a continuous adhesive line. And because of their failure to do that, actually there was a big void between the barrier and the wall. And of course, as I mentioned just a moment ago, the fire strategy was based on there being continuous fire barriers to prevent the spread of fire. And of course, that wasn't the case here. They did admit the installation breaches, but they denied the specification breach case. And they also denied that there was a need for replacement work scheme. There was an interesting argument raised that what they were saying was that because of the Grenfell Tower fire, effectively, there was an enhanced sensitivity about cladding of this kind. And so really all that was needed was repairs. And actually what Martlet were going to do was they were always going to pull down this cladding. So that's the no loss argument. So what they were saying was, look, employers all over the country are just taking this cladding down anyway. It wouldn't matter really what the problem was because of Grenfell, everybody was just doing it. So it really isn't our problem. It isn't really our default sort of prompted it. And so they said, look, really all you would have got was the repair costs. And actually, the waking watch losses were far too remote to claim. Next slide, please. Now, actually, what happened here was the judge largely resolved everything in Martlet's favour. The system that had been designed and specified did not comply with the fire safety standards that were current in 2005. And actually, this is a quite important point because this has been an element of dispute. There's been many parties that we've advised, which is that, generally speaking, there's been this confusion that after the Grenfell Tower fire, the law suddenly changed. That's not true. There were relevant standards in place before that. And so it wasn't a knee-jerk reaction because of the fire. There were actually obligations that you were required to comply with before then. And in this instance, the system failed to meet the functional requirements of the building regulations, and only modest reductions were made to Martlet's damages claim. Now, that claim was around £8 million. But you can easily see that it could have been much bigger. Next slide, please. So the approach that had to be taken was whether the system was designed meant that the external walls adequately resisted the spread of fire, having regard to the height, use and position of the building. Now, what was quite startling here was there was no evidence that Mulalley had actually even considered these points. So again, I think this is something that clearly will be addressed by the Building Safety Act and the Golden Thread and the idea of keeping live records throughout the whole life cycle of the building. But that's a really important point, that you make sure that you document any sort of approaches made in this regard. And in terms of the approved documents, this is not to be construed as meaning that whatever was not expressly prohibited was permitted and acceptable. So this was another thing that has confused the industry. The idea that because it wasn't, expressly written down that you couldn't use these things, it meant that, well, of course you can. Well, that isn't the case, and that was clarified by the judge. And in selecting and using a cladding system that included this combustible insulation, Mulalley had been in breach of its contractual obligations to exercise the same degree of skill and care in its design work as would an architect or other professional designer. Next slide, please. So in terms of the losses, this was an interesting point. So the losses were the diminution of value of the towers rather than the cost of replacing the cladding. So this is a bit different than how we normally assess damages in the construction sector. It wasn't the usual cost of cure assessment. And if the installation breaches had been the only breaches of contract, Martlet would only have been entitled to the lesser repair work scheme. So this is an important point of clarification again for the industry, because the judge actually explained what the alternative would have been. And in terms of the waking watch, these kinds of safety measures were certainly foreseeable. The judge actually goes into quite a bit of detail on this, and basically his view was it was obvious that you would do this sort of thing to alleviate any concerns as to safety, and it was definitely proportionate, because one of the other points that the judge considered was that, well, what was the alternative for Martlet? Just decant everybody and incur the cost of doing that and rehousing so many residents. So again, it was proportionate as well as foreseeable. Next slide, please. I've just included this quotation from the judge because I think it's really important and explains, I guess, again, the context. So what he said was this was an example of a culture of endemic complacency within the construction sector about the true nature and extent of the fire safety risk associated with the use of combustible external cladding on high-rise residential tower blocks. Now, that's quite a scathing remark, isn't it? And really, I think one of the things that we do need to consider is that, generally speaking, it's a lot to do with procurement and a lot to do with finite resources and the pressure on these projects and the profit margins being so low. But what happens is we all focus on one particular element. So in whatever instance it might have been, certainly here, insulation and making buildings perform better. And we'd focus on that, and then other things get missed off. And actually, this is really part of the culture of the sea change and the whole mindset change, really, of the industry that the Building Safety Act is seeking to achieve. Next slide, please. I thought here what we could do is just jump into the Building Safety Act. So we've explained what happened with Martlet Mulalley and the problems that this flagged. So what the Building Safety Act here is trying to do is directly address problems like this. So what we have is in the construction phase, the building safety regulator actually has the power to issue notices during the design and construction phase. So including compliance notices requiring issues of non-compliance be rectified by a set date, and stop notices requiring work to be halted until serious non-compliance is actually addressed. In terms of the in-occupation phase, the regulator can issue a compliance notice to an accountable person who appears to have contravened a relevant requirement. And if this notice is issued, the regulator must notify the local authority and the fire and rescue for that area. Now, you may have heard about the notification that's been given to the owners of Vista Towers. That's the big tower block in Stevenage. And apparently the regulator has another 23 buildings on their hit list. So it's clear they are going to use these powers. And in this instance, they've required the owners of Vista Towers to start the remedy works within 21 days, or they will be taken to court. So it's clearly trying to send a message to the industry that further to projects like what I've just described, we are actually going to use our powers and we're going to do something about it, because one of the worries was, well, it'd be all very interesting having this new legislation, but is it going to have any teeth? And clearly they're trying to demonstrate that it does. And then next slide, please. Now, in terms of what could happen, enforcement, fines, and imprisonment. So a failure to carry out in-occupation obligations or ignoring compliance or stop notices carries a threat of imprisonment or fines, or both, including upon summary conviction a maximum term of 6 months, increasing to 12 months, or upon indictment a maximum term of 2 years. So there is also that threat hanging over everyone. Next slide, please. Okay, so there's another really important part to this, which is the Act is introduced for purposes of bringing claims. Now, this has caused a big stir in the industry and is actually a really important as retrospectively, which is something that we haven't always seen with legislation. The Premises Act limitation period has been extended from 6 years to either 30 years for dwellings completed prior to June 2022 or 15 years for dwellings to be completed after June 2022. In terms of the statutory right to claim compensation for physical damage, where damage has been caused, it's 15 years from the date of the completed building works. In terms of liability for construction and cladding products, for construction products, it's 15 years from the date the right of action accrues, and for cladding, 30 years accrues. So that is quite startling and obviously is causing a bit of concern. But what I would say in summary is, while we've seen with Martlet, claims like this from employers will be entertained, it's of course important to resolve them where you can, because we do know that now, and we've had clarification from a judge. What the defective making and telling us all is that we really need to assess historic risks given the extended limitation periods, but also we need to assess them and try and resolve matters as soon as we can. But the positive thing and the real thing to take away here is that the industry is looking forward and we are working together for all of our safety, of course, which is only a good thing. Thanks very much.
Thank you, Theresa and Barry. Very interesting presentations. Welcome, everybody. So my presentation is about the cost of living crisis and construction. And they're not the most obvious subjects to cross over, but anyone who's working in the construction industry at the moment and looking back at the year in review will accept that these are very difficult times for construction. And often when difficult economic times hit, construction is the first industry to feel that pinch. In terms of what's being said, I don't want to start on too much of a downer, and apologies, I haven't got any polls here, so I'm feeling a bit inadequate. But Barry, your polls were a very good idea. I might look at those. The UK faces multiple serious economic, social, political threats. We've got inflation, looming climate disaster, trade disputes with the EU, persistent long-term impacts of the pandemic. So that's the RIBA. A 0.2% fall in GDP in September means Q3 was a technical recession, and the forecast, at least for ING Bank, and I'm sure others would agree, is that Q4 is going to continue in that fashion. So we are facing a recession. The question is, what can we do about it in construction? There are some silver linings. We've got infrastructure construction that looks that looks positive, at least for now, in terms of the larger projects continuing and likely to continue. The concern deep is looking at the reduction of planning applications and approvals, which suggests that obviously that work may contract, is likely to contract and already has. New work's progressing, but at lower profit levels, and that's something I'm going to talk about a bit later. And there are counter trends, of course, in London, such as some investment in hotels and rail projects. So on the next slide, I start to look at the causes behind this, and I don't want to pretend to be an economist, but it's pretty obvious. You can see that there are key indicators here and causes, starting with the war in Ukraine. Supply chains have obviously been impacted, inflation has been accelerated, and gas prices have surged, which has impacted energy prices and general prices. Obviously, we've got some ongoing impact from COVID-19, and that obviously impacts upon the supply chains, particularly in China at the moment, which is also, as you all know from reading the news, seeing the news, that you know, in China we've still got lockdowns in certain areas. And then we've got, obviously, we're facing inflation between 8%, possibly 18% next year. So things are going to get worse before they get better. Next slide, please. The other issues we've got is extreme weather. Energy production has dipped, pay is below the level of inflation, tax changes, cost of energy and fuel, as I've said, worker shortages, partly in the UK at least, relating to Brexit related visa issues, and there's a backlog at the Home Office you've probably heard of. And then one of the key issues is the inflation, direct inflation, the cost of building materials increasing, you know, up to 25% in some cases, and even higher. Metals and minerals prices are very volatile, and obviously the war in Ukraine hasn't helped that, particularly in relation to iron and steel prices. And then we've got the issue of timber costs and the impact of sanctions on the supply. Next slide, please. So that's all looking pretty gloomy, but there are certain key things, I think, that can be done to mitigate these things, and focusing on those in the construction industry. The questions, really, the key questions I think people should be asking is first of all, I mean, you've got to look at your contracts and your projects. But the questions are, has allowance for inflation been built into the prices that have been given? And obviously, if the answer is no, then the question deal with those risks? And the answer, in short, is that you need to look at the contractual provisions that are available and see if recovery can be made in some other way. For example, by way of claims. So effectively, we're talking about an increase in claims made under contracts in various different scenarios. And I'm going to take you through some examples of JCT, NEC and FIDIC provisions that will possibly cover these things. But in very simple terms, we're talking about loss and expense claims that can cover these increases in cost. The other way to deal with these things in a contract is by way of fluctuation provisions, but not all contracts have them. And those that do have limitations in the way that they're applied. Then you've got to think, are there sector-specific inflation risks, such as steel, iron, or other materials? And then consider whether the contracts that you've got fit for purpose. New contracts deal with those specific risks in the most appropriate way. Has inflation been forecast accurately for future work? It's imperative that if you're looking at pricing work for next year and beyond, that obviously you've got to get that as accurate as possible and build in as much of a contingency as you can. But also, the alternative is contract that deal with those fluctuations properly when they arise. And that's, I think, a good alternative to actually just building in whatever risk you think you're forecasting, because it's never going to be that accurate. Can rising input costs be offset by making delivery more efficient using digital solutions? And I do think this is an area that we should be focusing on more, which is keeping very good records of what's happening in markets, using models to forecast pricing, to order things in advance, to become more sophisticated ultimately in the way that we procure things. And if there are no provisions in the contract, what can I do? Well, as I said, you need to make claims and or negotiate if you don't have those provisions. Next slide. So that's the background. They're the sorts of questions you should be asking yourself. Turning to the legal principles, really there are sort of two key things that I would mention first of all, which are force majeure and frustration. Now, the first thing to note is that in English law, there is no standalone doctrine of force majeure. In other words, it won't be implied into your contract. So the only way you can rely upon force majeure is if it is defined in your contract as a right. And equally, because it's a contractual concept, its limitations and the effect of it will only be whatever the contract says. So you can define it very narrowly or you can define it very broadly. That's to be compared with the concept of frustration, which goes back to a wonderful case involving Edward VII, and where somebody had rented an apartment for the purpose of inviting a number of distinguished guests to a party to watch the coronation. And Edward fell ill and it was cancelled. So he tried to cancel his contract. And the question was whether it was beyond the reasonable control of the party, which clearly it was, and whether it was foreseeable. And it was decided that it wasn't. So effectively, the contract wasn't binding. And that was frustrated. So you've got frustration on the one hand, which is actually, as I'll come on to in construction contracts, but more interestingly, possibly, and more commonly used is the phrase force majeure. And as I say, it'll depend on what your contract says about that. So in terms of whether the war in Ukraine constitutes force majeure event, if it's an event beyond the party's control and is generally interpreted in that way, then and it's defined and it's within your contract, then it's most likely that the war in Ukraine is a force majeure event. And so therefore you should be able to rely upon the war as an event that gives rise to bringing a claim. The question will be, first of all, can you prove the link, the causal link between the war and the loss that you're seeking to recover? But perhaps more importantly, does the contract allow recovery for what you're seeking? And as you may know, contracts in relation to construction often separate the concept of time and money. And in most contracts, the standard contracts at least, as I'll come on to, you only get time for force majeure events as opposed to money. So there may be other ways that you may need to explore to recover the money side of the force majeure event. You may even need to recharacterize the cause of that loss. And I'll come back to that point. Next slide, please. So looking at the JCT contract, first of all, the provisions that allow you to recover extra money are what's described as relevant matters. But that's not to say that that's the only way you can recover. So the starting point, I think, would be, is the event, and if it's a force majeure event beyond the party's control, you've got to apply that test. But is it a change? Does the change entitle you to claim extra money for that work? And there's a very old principle, actually, that if contract works are delayed, then the increase in cost is something you can recover in principle. But the increase in cost in relation to the change is going to be the direct cost and not the indirect cost. The indirect cost is something you're going to need to try and recover as a matter of loss and expense. And you can only recover loss and expense under the JCT contracts in relation to relevant matters. So relevant matters include a change. So if there's been a change, you can claim for your increase in cost. You can also claim for a situation where materials are not available to be procured. So far as procurable is the sort of test. So if the war has caused certain materials to not be procurable, or indeed any other event has caused that situation, then you should be able to rely upon that as a change and therefore recover an extra cost for something new and the increased cost of that at the real-time price in the market. Fluctuations are dealt with, but they are optional provisions. So you can include within your JCT contracts the right to change and fluctuate your prices to reflect inflation or other indices that you choose, but they have to be defined in the contract. And if there are fluctuations that occur outside of what's been agreed, then they won't change the prices. Effectively, you can only fluctuate in accordance with the contract. Changes in the law, such as sanctions or COVID-19 related law changes or any other change post the base date, it is in the standard form at least something that gives rise to a change and therefore loss and expense. So you can get your increased costs in those circumstances. In terms of extra time, it's more narrow. You get any change. Force majeure is a ground for extra time, but not money, and changes in the law is equally. Next slide, please. So that's the JCT contract. Under the NEC contract, for those of you that don't know, there is a range of payment options. And essentially, up at the A and B end of the scale, you've got higher contractor risk, where you've got fixed prices. And then what will happen is, if there's a compensation event, which gives rise to a claim, which could include war or changes in the market beyond what's considered foreseeable, then those compensation events are valued on the basis of defined cost, which means you can get your increase in cost. So there's claims to be made there in respect of compensation events. But as far as the original prices are concerned, you're stuck with those if you're a contractor under options A and B. Options C and D are target costs. That means that you get paid effectively your defined cost, so whatever it costs you, so long as it falls within the schedule of cost components. But if you spend too much or over the target price, it will reduce your profit down, and there's a share of risk between the parties. And options E and F are effectively reimbursable, which means that you get all of your increases in cost at real time, and the client's effectively taking the risk of those things. So if you're under options E and F, you're effectively covered for fluctuations inherently. If you want to deal with fluctuations specifically in all of the options, then you have the choice to use secondary option X1. And what that does is it gives a framework under which you can apply fluctuations in the market and effectively reflect the real-time prices based upon certain indexes or indices. And those indices obviously have to be relevant to the works, is all I would say about those. And obviously, if you don't include certain indices, that are relevant, then you may not capture all of the changes in the market. So why would you do this? Well, because it's a transparent process. It avoids getting prices that are massively overinflated for works, which is a common theme at the moment because nobody wants to take the risk. And effectively, it shares the risk between the parties. There's also something to be said about the spirit of mutual trust and cooperation. I think you can probably trigger that provision if a contract is in a position where it's becoming very uneconomic and where the parties are having difficulty effectively making a huge loss on a contract. You could say, well, that triggers 10.2 and we need to work out a new way to move forward, and that could open the door to negotiations to try and adjust what's been agreed. And if you look at clause 60.119, that effectively defines force majeure. So events parties could not prevent stopping the contractor completing the works. You've also got changes in the law, and if the scope becomes impossible to perform, that's also a compensation event. So all of those things are expressly covered, and if they're compensation events under the NEC, you get time and money. Next slide, please. To compare these with the FIDIC contracts, and obviously the clause references will change depending on the version, same with the other NEC and JCT provisions here. Variations and value engineering proposals may be submitted to the party works in unforeseen circumstances. So that clearly covers anything that couldn't be foreseen at the time the contract was entered into. And then the parties can choose to include schedules of cost indexation. So again, that's a fluctuation option. And then there's a definition of exceptional event, which includes war, invasion, force majeure, and COVID-19. And then you've got changes in the law. So that's consistent really with the other provisions. And then which is slightly more narrow. So you've got variations, unforeseeable shortages in personnel, goods due to a government action, unforeseeable delays, disruption by public authorities, exceptional event beyond the contractor's control, including war and changes in the law of the country. So you can see that there are slight differences in terms of the way the standard forms deal with these risks. Next slide. So how should you protect your contracts and how should you protect your interests? Before we go into the practical steps, I would suggest just a mention of frustration. So if you get to the point where the contract can no longer be possibly performed, and a good example of this is the Taylor and Caldwell case from 1863, where Surrey Music Hall burnt down after there'd been an agreement to use it for a lavish party over 3 days. And that it was held is an event which effectively makes the contract impossible. The contract becomes void. But it must be said that this is interpreted quite narrowly, particularly in the context of construction and commercial contracts, and there are limitations. In this case here from 1962, the Suez Canal was closed. An alternative route via Cape of Good Hope was possible, even though it would incur a significant delay and additional cost. And the court said that I'm afraid that's not a frustrating event, simply because it's going to cost more. And then there was some statutes introduced in 1943 here, the Law Reform Act, which effectively said that if there was a frustration, to reflect the case that had come previously, what happens? Well, what happens is that if you pay, essentially you can get your money back. So that's frustration. And as I say, that happens in fairly narrow circumstances, but it is possible that it's relevant to your project. In terms of the NEC contract and the other contracts and how they deal with this, that it's recognised in the NEC under 91.5 here, it's discharged by law is the phrase, but it also says the contract if in the absence of default by the contractor or client, PM stops work for more than 13 weeks. and the employer may terminate when action prevention causes forecast delay by more than 13 weeks. So there's a 13-week period there, which could trigger termination, which is another route to potentially try and resolve, the position where you're in a contract which is completely uneconomical to run. Next slide, please. So under the FIDIC contract, either party may terminate if an exceptional event causes a delay of 84 continuous days or multiple delays totaling more than 140. And it's interesting, the exceptional event here does not require the event or circumstance be unforeseeable. So, if your contract starts after the war has commenced and and an event prevents your contract from continuing for more than 84 continuous or 140, then there is a right to terminate. And then either party is entitled to serve a termination notice if any event arises outside the control of the party, making it impossible. And that's a straightforward frustration provision. Under the JCT, either party may terminate on notice if suspension for force majeure continues for more than 2 months. And there's the case of Lobopan here that confirms that pandemic is a force majeure event. So the 2-month cutoff is relevant for the JCT. Next slide. So what should we be doing about all of this? Well, it depends on obviously what type of entity is considering these risks, but there are a number of things that can be done practically. Obviously, in relation to new contracts, the key is going to be in the drafting of those, and specific bespoke provisions to deal with fluctuations, I think, is definitely going to be something that needs to be done. A review of the prices and works programs on those live projects that you have, I think, is critical, and to really focus on perhaps the most important strategic contracts and the highest value contracts first, dealing with the supply chain, making sure that if you can stockpile, if you're fixed to prices, you could de-risk in relation to trying to agree reimbursable contracts, but that's difficult. Employers may consider fixed price tenders to limit their exposure. Inclusion of fluctuation provisions I've mentioned. So the key thing about all of these approaches is that you've got to keep records to pursue such claims, and protecting your contractual position under current projects, as I say, and ensuring new projects are agreed on terms that can reflect these changes in the market is incredibly important. And then finally, I mentioned this earlier, but I do think it has a big part to play. Digital solutions whereby records can be kept and maintained, forecasting of costs and procurement processes and monitoring of those things, feeding into programs, I think is going to be a key part of the solution. So in summary, if you're funders or developers, you've got to be looking at doing more due diligence in relation to the construction documents. If you're contractors, you're really going to need to assess the projects that you have and make sure you do a thorough review of those most strategic and highest value projects to make sure that you can maximize your recovery. And obviously down the line, the key is going to be bringing claims, and those claims can only be brought where you have a contractual right, where you have followed the contractual process, and of course, where you can prove your entitlement and the losses that are being claimed. And most importantly, you can prove the link between those events and the losses that you're seeking. Thank you very much. That's the end of my presentation. Back to you, Rebecca.
She needs to let me put my video on, Sophie. So, Sophie.
You're on, Rebecca.
Yes, thank you. Sorry, there was something wrong with my video function. So thank you very much, everyone, for attending today. Obviously, we had a lot of material to cover today, and so we've run out of time for the Q&A. However, so if you do have to drop off, that's totally understood. But if you'd like to stay on in the Q&A, or hear some of that discussion, then please do. If you are leaving us and if you dialed into the webinar, could you please email events@wfw.com just so that we know that you attended. Later on today, you'll receive a follow-up email which will include the slides and some relevant materials and a short feedback survey. It just takes a few minutes to fill in. So if I could sort of urge you to do that, that would be greatly appreciated. And that's so that we can obviously ensure that we're delivering events that are engaging and relevant. Finally, the webinar will be recorded. So don't worry, if you'd like to revisit any of the presentations, you can catch them on our YouTube post, the WFW YouTube account. And so now we've just got a couple of questions, and I am going to ask the first one of Theresa. Theresa, is the Martlet case a green light for employee claims?
Thank you, Rebecca. I think it's certainly a green light to an extent, because if you can demonstrate installation breaches, breach of specifications, the case has shown us that you will get the costs of a full replacement scheme, not just repairs, and also other costs like a waiting watch scheme. And another question we got, it was a question about whether or not the building safety reform, including the Caribbean. And actually one of our lawyers here, Emma Thompson, she's dual qualified. So we asked her in advance of this session. And basically what she said is, whilst the architecture in the Caribbean hasn't traditionally lent itself to these sorts of issues that we're seeing over cladding, there has been a migration to the cities. And so the way that they are constructing residential property now will include high rise. And so there may be issues like this to consider. And certainly with some of the international contractors like here that build in the Caribbean, you would hope that they will adopt principles that they've learned here, even though there may not be legislation that specifically requires it. But another interesting point that Emma raised as well was that whilst they may not have the same issues with cladding, what she has noticed in that jurisdiction is that they do use sprinklers quite widely. So there are other measures that they are actually importing, which without specific legislation actually requiring it. So that's a very good news story.
Thank you very much, Theresa. I'm now going to ask a question of Barry. So Barry, is Abbey and Simply just about collateral warranties and not third-party rights? Hasn't it already been decided that adjudication doesn't apply to third-party rights?
I think that's a really, really good question. So the question was referring to this 2014 decision, Hurley, Palmer, Flatt and Barclays, where an adjudicator's award that related to an adjudication arising out of a third-party rights schedule wasn't enforced. And that decision has always on the basis that adjudication doesn't apply in cases of third-party rights. But I don't think that is the right answer, because the case is about who can refer a claim to adjudication on the circumstances in that case, rather than whether adjudication applies to third-party rights. So I would say the principle of whether adjudication applies to third-party rights hasn't been decided to date, because that wasn't the issue in respect of Hurley, Palmer, Flatt. And in any event, even if that had been decided in Hurley, Palmer, Flatt, I would say as a result of the Court of Appeal decision in Abbey and Simply, that effectively means that everything is now up for grabs. And what you need to do is you need to assess each document in the construction pack, and you need to look at this past and future warranty in relation to performance, and you need to look at this Section 109 requirement in respect of payment in order to assess whether there's a possibility of applying statutory adjudication rights. But this is certainly a point that's likely to be revisited. We should keep our eyes out for any further developments in this area in the future.
Thank you very much, Barry. And we've got time. Well, we don't have time, but we do have another question. And this one is for Ryland. Can a party claim force majeure if a contract becomes uneconomic to perform?
Yeah, thanks, Rebecca. The short answer is no, simply because contracts become uneconomic doesn't necessarily mean that it represents force majeure, and in fact, it will depend on the contractual provision. So if the definition force majeure is very broad, and it specifically deals with the contract being uneconomic, then it would have to be reasonably certain. And in those circumstances, then there is a possibility that it's covered. But I don't think I've ever seen a clause that broad. So the short answer is that ordinarily it would be no. And if you wanted the contract to reflect changes in the market, then you would require fluctuation provisions to be incorporated.
Okay, thank you very much, Ryland. Well, that brings us to the conclusion of today's webinar. Once again, thank you very much for attending. And please do fill in the feedback questionnaire and obviously have your eyes peeled for the slides and other materials which will be sent to you later today. So have a good day, everybody. Thank you. Bye.